Let's have a look at how damages would be calculated due to defective works. So the thing to note here is that when it comes to defective works, we're concerned with residential building works. And the reason that I say that is because Section 18B of the Home Building Act, which is the relevant statute that we will be looking at, only applies for residential buildings. So if I were to summarize Section 18B for you, basically it says that whenever there's a licensed contractor performing residential works on a building, then the contractor would be liable for certain warranties that are implied in the contract. Now, these warranties are referred to as statutory warranties, recall, and these are ones that would be implied even if they're not expressly mentioned in the contract. Such warranties cannot be avoided by the contractor, so they have to comply with these warranties that I mentioned. And examples of such warranties are listed down on the screen for you. So, for instance, fitness for occupation. The building has to be fit for people to occupy it. The work has to be done with due care and skill, etc. How would damages be calculated if it were due to defective works? The authority case is the one highlighted for you on the screen. Damages would equate to the cost of rectifying the defect. So it's the cost to make the building conform to the plans. And the simple equation that's given is market price minus contract price. Now note that if the breach is remote, such that you can't establish causation, in this case, there will be no compensation. And if there's no compensation, then there is no damages. And the authority case is the one highlighted for you on the screen. Let's have a look at an example to demonstrate how the equation works when it comes to defective work damages. Say, for example, I paid $100,000 for a contractor to construct a retaining wall for me. The contractor delivered a faulty wall, and that resulted in me going out, finding someone else to fix it. So I had to pay an extra $35,000 to get it fixed. Overall, the market value for that wall would be $100,000 plus the $35,000 that I paid, so $135,000. In terms of the damages that I can claim from the contractor, it would be market price, which is $135,000, how much I paid overall, minus the contract price, which is $100,000. So I can claim $35,000 in damages, and these $35,000 equate to the cost of rectifying the damage in the wall. In certain cases, the court can order for a whole building to be deconstructed and a new building to be reconstructed. And this was the case in the case highlighted on the screen. Now, if I were to summarize this case for you, basically it was a building that had a faulty concrete foundation system, and underpinning wasn't sufficient to solve the issue. So what the court did was it ordered that the building be deconstructed and a new building be reconstructed. Now, this is not always the case, so such actions wouldn't be ordered by the court in all cases. It depends on the facts. But for the court to order such a action, it has to have deemed it necessary and reasonable. In cases where it's not found to be reasonable and necessary to do so, to deconstruct and rebuild a building, then what the court would order is that it would specify that the plaintiff, the injured party, be compensated for the loss in value that takes place because of the defect. So let's say, for example, you had some fault, right? It was a fault in the concrete. It wasn't a safety hazard. So there was no safety concerns with the fault. But it's just that aesthetically, it looked unpleasant. So instead of asking for the whole building to be deconstructed, if the court deems that such an action is unreasonable, instead it would order for damages to be paid in the value of the loss in value of that building to the innocent party.